My name is Edward Halloran, and the morning two strangers from Adult Protective Services stood on my front porch, asking to come inside and interview me privately about allegations that I was being abused in my own home. Was also the morning I understood that my daughter had decided to move against me before I ever had the chance to finish protecting myself from exactly this. It was a Tuesday, cold enough that frost still covered my front steps, when I opened the door to find a woman in a gray coat holding a laminated county badge and a folder, a sheriff's deputy standing a respectful few steps behind her on the walkway. "Mr. Halloran, my name is Carol Whitfield. I'm with Adult Protective Services for St. Louis County. We received a report expressing concern about your welfare, and we're required to follow up with a wellness check and an interview. May we come in?" I stood in that doorway, 74 years old, in reasonably good health for my age, mentally as sharp as I'd ever been according to every doctor who'd examined me in years. And I felt a particular kind of vertigo, the sense of the ground shifting beneath a life I'd believed was entirely stable and entirely my own to manage. "What exactly is the concern?" I asked. "And who reported it?" "I'm not able to disclose the reporting party at this stage," Carol Whitfield said, gently but firmly. "But the report alleges possible financial exploitation and neglect involving a caregiver in your home. We take these reports seriously regardless of source, and we need to conduct a private interview with you to assess your well-being." I let them in, because refusing would have only made the entire situation look more suspicious than it already felt, and I sat in my own living room answering questions about my finances, my medications, my daily routines, and my relationship with Teresa Alvarez, the woman who had been coming to my house 3 days a week for the past 3 years. Initially, as a hired home health aide, and over that time, as someone who had become one of the most important people left in my life. I didn't know, sitting in that living room, answering Carol Whitfield's careful, probing questions, that my own daughter Danielle had filed that report 4 days earlier, and that she had done so, I would learn over the following weeks. Specifically because she'd found out I intended to update my estate plan in a way she'd decided, without ever discussing it with me directly, she couldn't allow to happen. I need to back up considerably further than that Tuesday morning to explain how a father and daughter end up in a place where one of them calls the authorities on the other, rather than simply picking up the phone. I spent 38 years working for the railroad, first as a conductor and eventually as an engineer, running freight lines across northern Minnesota in every season this state has to offer, brutal winters and short, brilliant summers, the kind of work that builds a particular relationship with solitude and self-reliance that stays with a man long after he retires. My wife Joan taught piano lessons out of our home on Lakeview Drive in Duluth for most of our marriage, and together we raised 2 children, my daughter Danielle and my son Peter, in that same house, a modest but comfortable life built on 2 steady incomes, and Joan's remarkable gift for making every dollar stretch further than seemed reasonably possible. Peter moved to Seattle after college, built a career in software engineering, and though the distance kept his visits infrequent, we maintained a close, easy relationship over the phone, weekly calls that never felt like an obligation for either of us. Danielle stayed closer to home, settling in a suburb about 40 minutes from Duluth, and for most of her adult life our relationship was, if not effortless, at least stable and warm. Holidays together, regular visits, the ordinary rhythm of a father and daughter who genuinely cared for each other even when life got busy on both ends. John passed 6 years ago, a stroke that took her within a matter of days, and her death hit Danielle particularly hard, harder in some ways than it hit Peter or me, though I want to be careful not to rank anyone's grief against another's. What I noticed, in the years following Joan's death, was a gradual shift in Danielle's own life circumstances that eventually became relevant to everything that followed. Her marriage to her husband Kyle began deteriorating about 4 years ago, ending in a divorce 2 years later that left her in a considerably more precarious financial position than she'd been in previously, a modest condo, a demanding but unstable freelance consulting career, and mounting credit card debt she mentioned to me only in vague, uncomfortable terms during our occasional conversations. I had a knee replacement surgery about 3 years ago, a routine but significant procedure that required several weeks of in-home physical therapy and assistance with daily tasks I couldn't manage entirely on my own during the initial recovery period. My physical therapist's office connected me with a home health aid service, and that's how Teresa Alvarez first came into my life, initially scheduled for 3 visits a week, over a 6-week recovery period that both of us, at the time, assumed would simply end once I'd fully recovered. Teresa had worked as a home health aide for over 15 years by that point. A warm, practical woman in her early 60s, widowed herself for about a decade, and something about our early conversations during those physical therapy sessions developed into a genuine friendship that neither of us had particularly anticipated. By the time my recovery officially concluded, I'd asked Teresa if she'd be willing to continue coming by a few times a week, not for medical necessity anymore, but simply for the company, an arrangement I paid her fairly for, though I want to be honest that our relationship had, by that point, grown into something considerably warmer than a simple professional arrangement. Over the following 2 years, Teresa and I became genuinely close, sharing meals together several times a week, taking walks along the lake when the weather allowed, developing the kind of comfortable, easy companionship that I hadn't expected to find again after losing Joan. I want to be careful in how I describe this relationship, because it matters considerably to what followed. Teresa and I were not romantically involved in any dramatic sense, though I won't pretend there wasn't real affection between us, a partnership of sorts between two people who'd each lost a spouse and found in each other's company something neither of us had expected to find again at this stage of our lives. I mentioned Teresa to Danielle occasionally over those 2 years, describing her simply as someone who helped around the house and had become a good friend, and Danielle, as far as I could tell, never expressed any particular concern about the arrangement, though in hindsight, I don't think I ever fully described how central Teresa had become to my daily life and my own happiness. About 4 months before that Tuesday morning knock on my door, I made a decision, after considerable thought, to update my estate plan with my longtime attorney, a careful, thorough woman named Linda Ostrander, who'd handled my legal affairs for over 15 years. I wanted to formalize a modest provision for Teresa in my will, not the bulk of my estate, which I still intended to divide primarily between Danielle and Peter, but a meaningful bequest, $40,000, and a small piece of lakefront property I owned separately from my primary residence. In recognition of the genuine companionship and care she'd provided over the previous 3 years, care that had gone well beyond anything her original professional role had required of her, I mentioned this decision to both Danielle and Peter directly, wanting to be transparent about it before finalizing anything, precisely because I understood, even at the time, that introducing a non-family beneficiary into an estate plan can sometimes create tension within a family, and I wanted to handle that transparently rather than let anyone discover it as a surprise after my death. Peter's reaction, when I called to tell him, was straightforward. "Dad, if Teresa's meant that much to you, and it sounds like she has, that seems completely reasonable to me. I trust your judgment on this." Danielle's reaction was considerably different. "Dad, are you serious? You're leaving property to your home health aide? Have you really thought this through? What if she's been, I don't know, taking advantage of you somehow? You're 74, Dad, and I don't think it's unreasonable for your own daughter to have some concerns about a caregiver suddenly ending up with a piece of your property." I want to be honest that I understood, even at the time, that Danielle's reaction carried a legitimate strand of protective concern buried within it, the kind of question any caring adult child might reasonably ask about a parent's late-in-life relationships. What I didn't understand at the time was how quickly that legitimate concern would curdle, in the following weeks, into something considerably darker and more calculated. I learned much later, through the discovery process that followed the events I'm about to describe, that Danielle's reaction to my estate planning decision had been shaped considerably by her own deteriorating financial circumstances. Her divorce settlement had left her with significantly less than she'd anticipated. Her freelance consulting income had grown increasingly unreliable over the previous year, and she had, unbeknownst to me at the time, begun quietly counting on her eventual inheritance from my estate, including a meaningful expectation around the value of my house on Lakeview Drive. As a critical piece of her own long-term financial stability, the prospect of even a modest portion of my assets going to Teresa, combined with her own mounting financial desperation, appears to have triggered, in Danielle, a spiral of anxious calculation that ultimately led her toward the decision that brought two strangers to my front door that cold Tuesday morning. What I would learn, again through the legal discovery process that followed, was that Danielle had spent the weeks after our conversation about my estate plan, quietly researching what legal mechanisms existed for challenging a parent's competency or protecting a vulnerable elder from potential exploitation. Research that eventually led her to Adult Protective Services and, separately, to an attorney who specialized in guardianship and conservatorship petitions. Danielle filed a report with Adult Protective Services, alleging that I was showing signs of cognitive decline that made me vulnerable to financial exploitation, and that Teresa specifically had been exerting undue influence over my recent estate planning decisions. Allegations that, while carefully worded to trigger a mandatory investigation, had no genuine factual basis in my actual mental state or my relationship with Teresa. Simultaneously, and this is the piece that alarmed me most once I fully understood the scope of what had happened, Danielle filed an emergency petition in county court seeking temporary guardianship and conservatorship over my person and my finances, citing the same allegations of cognitive decline and vulnerability to exploitation, a petition that, if granted even on a temporary emergency basis, would have given her legal authority to freeze my finances, restrict access to my accounts, and potentially block any further changes to my estate plan while the matter worked its way through the court system. I sat in Linda Ostrander's office 3 days after that Adult Protective Services visit, having received formal notice of the emergency guardianship petition, trying to process the full scope of what my own daughter had done. "Ed, I want you to understand the seriousness of what we're dealing with here," Linda told me, her expression grave. "An emergency guardianship petition, if a judge grants even a temporary order, could result in significant restrictions on your autonomy while this gets sorted out. Restrictions that would remain in place for weeks or potentially months while a full hearing gets scheduled. We need to move quickly and thoroughly to demonstrate that these allegations have no factual basis." I want to walk through the weeks that followed, because they represent one of the most disorienting periods of my entire life, a strange, surreal experience of having to formally prove, through medical evaluation and documented evidence, something that should have been self-evident to anyone who actually knew me, that I remained fully capable of managing my own affairs and making my own decisions. Linda arranged for an emergency cognitive evaluation with a respected neuropsychologist, Dr. Samuel Kwan, who conducted a comprehensive assessment over 2 separate sessions, testing memory, reasoning, executive function, and decision-making capacity through a battery of standardized instruments. Dr. Kwan's findings, delivered in a detailed written report about a week later, were unambiguous. My cognitive function fell entirely within the normal range for my age, with no indicators whatsoever of dementia, significant memory impairment, or any condition that would compromise my capacity to make sound financial or legal decisions. Linda also gathered statements from my primary care physician, Dr. Renata Alvarado, who had treated me for over a decade, and could speak directly to my consistent mental clarity across every recent appointment, along with statements from several neighbors and longtime friends who could attest to my continued active engagement in community activities, my ongoing volunteer work at the local historical society, and the general sharpness and independence they'd observed in me throughout the previous several years. Perhaps most significantly, Linda's investigation into the actual origins and timeline of the guardianship petition uncovered a piece of evidence that would prove critical to the eventual resolution of the entire situation. Through the discovery process, Danielle's own text messages with her ex-husband Kyle, subpoenaed as part of the guardianship proceeding, given his relevant knowledge of her financial circumstances, revealed a conversation from several weeks before the Adult Protective Services report was filed, in which Danielle had written, with a directness that would prove devastating to her case once it surfaced in court, something to the effect that she needed to move fast before her father, quote, signs anything over to that woman, and that she'd found a way to, quote, freeze everything before he can finalize it. I want to be honest that reading those text messages, once Linda shared them with me during our case preparation, produced a grief in me that was considerably more complicated than simple anger. I understood, reading my daughter's own words describing a calculated plan to freeze my finances and challenge my competency purely to protect her own anticipated inheritance, that this hadn't been a case of genuine, if perhaps overzealous, concern for my welfare. It had been a deliberate, premeditated strategy, using the language and mechanisms of elder protection law as a tool against the very elder those laws were designed to protect. Peter, once he learned the full scope of what Danielle had done, flew in from Seattle immediately, staying with me through the weeks leading up to the guardianship hearing, offering testimony of his own regarding my consistent mental sharpness during our regular phone calls, and expressing, in conversations we had late into several evenings, a genuine bewilderment about how his sister had arrived at a decision this serious and this calculated. "Dad, I don't understand how she got to this point," Peter said, one evening about a week before the scheduled hearing. "I know the divorce hit her hard, financially and otherwise, but this isn't just poor judgment. This is a plan. She researched guardianship law. She filed a false report with Adult Protective Services. She was building a legal case against her own father's basic autonomy, and based on those texts, she knew exactly what she was doing the whole time." Teresa, for her part, bore the brunt of a particularly painful set of allegations throughout this entire process. Her professional reputation and her personal integrity called into direct question by a woman she'd never had any significant conflict with prior to this. She provided her own detailed statement to Linda, along with financial records demonstrating that she had never received or requested any money or gifts from me beyond her standard hourly compensation for caregiving services, and character references from previous clients and employers spanning her entire 15-year career, none of which contained any prior indication whatsoever of financial impropriety or undue influence. "I've never once asked you for anything beyond what our arrangement always was," Teresa told me during one particularly difficult evening as we worked through the case preparation together. "I care about you, Ed, genuinely, and I understand why that provision in your will might look complicated from the outside to someone who doesn't know the actual history between us. But I never once manipulated you into anything. I need you to know that I understand if all of this makes you want to step back from our arrangement, given how much scrutiny it's brought into both our lives." "It doesn't make me want to step back at all," I told her honestly. "If anything, watching my own daughter try to use our relationship as a weapon to control my finances has made me considerably more certain that the decision I made about including you in my estate plan was the right one." The guardianship hearing took place about 6 weeks after that initial Adult Protective Services visit in a modest courtroom in the St. Louis County Courthouse, presided over by a probate judge named Harriet Ossie, a careful, experienced jurist who had clearly reviewed the extensive filings from both sides in advance. I want to describe that hearing in some detail because it represents, in the fullest sense, the formal reckoning this entire ordeal had been building toward. Linda presented our case methodically, beginning with Dr. Kwan's comprehensive neuropsychological evaluation, walking Judge Ossie through the specific test results and standardized scores demonstrating my full cognitive capacity. Dr. Renata Alvarado testified next, confirming a decade of consistent medical observation showing no indication of cognitive decline. Several neighbors and longtime friends testified briefly about my continued independence and community engagement. Peter testified about his regular phone conversations with me over the previous several years, describing in specific detail the sharp, engaged, thoroughly capable father he'd continued to speak with weekly, and expressing his own direct observation that nothing about my behavior or decision-making had changed in any way that could reasonably support concerns about cognitive decline. Teresa testified about the actual nature of our relationship, the financial records demonstrating no impropriety, and the character references spanning her entire career, providing a clear and detailed account that directly contradicted the allegations Danielle's petition had raised against her. Then Linda introduced the text message exchange between Danielle and Kyle, entering it into evidence and walking Judge Ossie through the specific language, the explicit reference to needing to move fast before I could finalize my estate plan, the explicit reference to freezing my finances rather than any genuine concern about cognitive decline or exploitation. Danielle, called to testify about the origins and basis for her Adult Protective Services report and her guardianship petition, grew visibly less composed as the hearing progressed. She initially maintained that her concerns about my welfare were genuine and had developed independently of any concern about her own inheritance. But under Linda's careful cross-examination, referencing the specific language in her own text messages, that framing became increasingly difficult for her to sustain. "Mrs. Halloran," Linda asked, reading directly from the text exchange, "you wrote to your ex-husband that you needed to, quote, move fast before your father signs anything over to that woman," end quote. Can you explain how that statement reflects a genuine concern about your father's cognitive welfare rather than a concern about protecting your own anticipated inheritance? Danielle sat in the witness chair for a long moment before answering, and I want to describe what I saw on my daughter's face during that pause, because it revealed something I hadn't fully expected. She looked, in that moment, less like someone caught in a lie, and more like someone finally confronting, in front of a judge and her own father, the full weight of a decision she'd made in a state of financial panic she'd never previously allowed herself to examine honestly. "I was scared," she finally said, her voice breaking. "I was scared about my own financial situation, and I convinced myself that Dad's decision about the will meant something was wrong with him, because it was easier to believe that than to admit I was afraid of losing money I'd been counting on without ever really having any right to count on it in the first place." Judge Osei, after hearing the full body of testimony and evidence, did not require an extended deliberation before delivering her ruling. This court finds no credible evidence supporting the allegations of cognitive decline or financial exploitation raised in the petitioner's filing. The comprehensive neuropsychological evaluation, corroborating medical testimony, and character testimony from multiple independent sources all affirm Mr. Halloran's full mental capacity and continued ability to manage his own affairs. Moreover, this court finds the petitioner's own contemporaneous communications considerably more consistent with a motive to protect anticipated personal financial interests than with any genuine concern for her father's welfare. This court denies the petition for guardianship and conservatorship in its entirety. Judge Osei paused before continuing, her expression serious. "Given the seriousness of filing what appears to be a substantially false report with Adult Protective Services, and given the apparent use of this court's emergency guardianship process for purposes unrelated to genuine elder protection, this court is referring this matter to the county attorney's office for review of potential penalties associated with false reporting under state law." I want to walk through what happened in the weeks and months following that ruling, because the story doesn't simply end with a judge's decision. Danielle, facing the referral to the county attorney's office, retained her own separate legal counsel to navigate that process, which ultimately concluded with a formal warning and a modest civil penalty related to the false report rather than more serious criminal charges. Given the absence of any prior similar conduct on her part and the county attorney's assessment that the matter was best resolved through penalty and mandated counseling rather than prosecution, I want to be honest that my relationship with Danielle in the months following this entire ordeal has been considerably more strained and uncertain than my relationship with Craig was. For the family in a similar situation I once heard about secondhand from a friend, and I think that difference matters to being honest about how these situations don't always resolve into tidy forgiveness on any predictable timeline. Danielle reached out to me about 4 months after the hearing, asking if we could meet, and I agreed, cautiously, meeting her at a coffee shop rather than at my house, wanting some public neutral ground for a conversation I anticipated would be difficult. "Dad, I don't have any excuse that makes what I did okay," she said, sitting across from me, her hands wrapped tightly around a coffee cup she never seemed to actually drink from. "I let my own financial fear turn into something that could have taken away your basic right to make your own decisions about your own life. I researched how to do it. I planned it out. I used the exact language I thought would trigger the response I wanted from Adult Protective Services and from the court. That's not a moment of poor judgment, Dad. That was a calculated plan, and I need you to know that I understand the difference, even though understanding it doesn't undo any of the damage. Why didn't you just talk to me?" I asked her, the same question I imagine most parents in my position eventually ask. If you were struggling financially, if you were scared about your own future, why didn't you just tell me directly, the way Peter and I have always been able to talk to each other? "I think I was ashamed," Danielle said quietly. "Ashamed of the divorce, ashamed of how badly my finances had fallen apart, ashamed enough that admitting the truth felt harder than trying to control the situation through a legal process that let me avoid ever actually saying the words out loud." I sat with that explanation for a long moment, and I want to be honest that it didn't erase the pain of what she'd done, the strangers on my porch, the neuropsychological evaluation I'd had to undergo, simply to prove I remained capable of running my own life, the specific cruelty of watching my daughter attempt to weaponize concern for the elderly against an elderly parent who had never once given her genuine reason for that concern. "I need you to understand," I told her, "that rebuilding any trust between us is going to take considerably longer than one conversation, and it's going to require more than an apology, however sincere. It's going to require you actually getting help for whatever led you to a place where this felt like a reasonable solution to your problems. And it's going to require a lot of time before I feel comfortable believing you wouldn't do something like this again if you found yourself scared and desperate in some future crisis." "I understand that," Danielle said. "I've already started seeing a therapist, specifically to work through the shame and the financial anxiety that drove this. I'm not asking you to trust me right away. I'm asking for the chance to earn it back, slowly, over whatever time that actually takes. I want to be honest that I don't know, even now, several months after that coffee shop conversation, exactly where my relationship with Danielle will eventually land. We speak occasionally cautiously, and I've noticed in those conversations a genuine effort on her part to be more honest about her own struggles rather than letting shame calcify into the kind of desperate, calculated action that led to that Tuesday morning knock on my door. My relationship with Teresa, meanwhile, has only deepened through this entire ordeal. Both of us having weathered something considerably more serious than either of us anticipated when we first met during my knee replacement recovery 3 years ago. I finalized the estate plan update with Linda. About a month after the hearing concluded, the same modest provision for Teresa I'd originally intended, unchanged by everything that had happened because I refused to let a false accusation dictate a decision I'd made with clear eyes and sound judgment in the first place. Peter has remained a steady, consistent presence throughout this entire process, and I've noticed, in the months since, a considerably closer relationship developing between us, built on the foundation of his unwavering support during the hardest weeks of this ordeal. I sat on my back porch last weekend, looking out at the same lake Joan and I had watched together for over 3 decades. Teresa beside me, Peter visiting for the weekend, and I understood something I don't think I'd have understood as clearly without that terrifying morning when 2 strangers stood on my porch asking to interview me about my own capacity to run my own life. Age doesn't automatically strip a person of their judgment or their right to make their own decisions. However inconvenient those decisions might be for the people around them who've built certain expectations about what they're owed. The laws designed to protect vulnerable elders from genuine exploitation matter enormously, and they exist because real exploitation genuinely happens. But those same protections can be turned, in the wrong hands, into tools of control rather than care, and the only real defense against that kind of misuse is the same thing that's always mattered most: clear evidence, honest testimony, and people willing to stand up and tell the truth when it actually counts. If this story reminded you of an aging parent in your own life whose autonomy might be at risk, whether from genuine concern or from someone else's less honest motives, please make sure any guardianship or protective proceeding is grounded in real, documented evidence rather than assumption, and make sure the elder at the center of it has access to their own independent legal counsel and medical evaluation before any decision gets made on their behalf. And if this story stayed with you, share it with someone who needs to hear it, and subscribe for more true stories about family, justice, and the fight to protect what's rightfully yours.